In this lecture series, we're going to be covering chapters 7, 8, and 9. Chapter 7, Capacity to Contract. For an agreement to be enforceable, all parties must have contractual capacity. The law presumes that parties have the capacity to contract. However, some parties lack the capacity to contract based on age, physical condition, public policy, or mental condition. If you're following along in your textbook, 7.1 discusses minors, contracts of minors. A contract with a minor, someone under the age of 18, is voidable at the minor's choosing. Adults cannot avoid contracts made with a minor if the minor decides to go forward with the contract. Contracts between two minors are voidable for both. 7.1b, contracts that cannot be avoided, contracts of minors for necessaries, minors' business contracts, and other enforceable contracts such as educational loans, legal duties, and medical care. So these are contracts that even a minor can't avoid. Contract for necessaries, food, shelter, clothing, so forth. Seven 1b, contracts that cannot be avoided: continued disaffirmance, repudiation of a contract. A minor cannot disaffirm voidable contracts at any time during the time that they are a minor. There is a brief time to disaffirm a contract after the minor becomes an adult. The ratification of a contract, a minor indicating the willingness to be bound by a contract, even though the contract is voidable, is the ratification of that contract. All or none of the contract must be modified or ratified by the minor. So how do you contract safely with minors? This is discussed in 7.1c. Get the parent or guardian to co-sign with the minor. So when an adult co-signs, that will obligate the parties. The other party has the right to sue that adult who co-signed with the minor. 7.1d, minors' torts. A minor is fully liable for torts as an adult is. Misrepresentation of age can result in unavoidable contract, but this is a non-uniform rule. Seven 2 discusses mentally incompetent people. Incompetence can be the result of stroke, dementia, retardation. Contracts made with persons who have formerly been adjudicated incompetent are void, not voidable, void. Means the contract is terminated. A person not declared by a court to be incompetent, the contracts are voidable. A person must understand a contract is being made at the time it is being made. 7.3 discusses intoxicated people. Contracts made with people who are intoxicated are voidable. When sober, that person may affirm or disaffirm the contract that was made while intoxicated. A person legally declared a habitual drunkard cannot make contracts, nor can they serve on a jury. These rules apply to those using drugs as well. Convicted felons, although many states have repealed laws restricting convicts or people convicted of felons to contract, limitations may prevent convicts or people convicted of felonies to contract until out of imprisonment or parole. Chapter 8 discusses consideration. 8.1 The nature of consideration. Consideration is what the promisor, the person making the offer, requires as the price for a promise. The exchange of a promise for a promise creates a contract. Adequacy of consideration. Part payment or partial payment. A creditor is entitled to part payment, if not full payment, for the promise. Therefore, part payment is not consideration because it's something that's already owed. However, if the amount of the debt is in dispute, the debt is canceled if a lesser sum than that is claimed is accepted in full settlement. If there is more than one creditor and each one agrees in consideration of the other's agreement to accept in full settlement a percentage of the amount owed, this agreement will cancel and the unpaid balance due to these creditors will be satisfied. This is known as composition of creditors. If the debt is evidenced by a note or other written evidence, cancellation and return of the written evidence cancels the debt. 8.2a, if the payment of the lesser sum is accompanied by a receipt in full and some indication that a gift is made of the balance, the debt may be canceled. So if you dispute a debt, if you send a check to the person who claims they're owed money for the amount that you believe is owed, and in the memo line you put paid in full, if the person you sent the check to deposits or cashes that check, then they are accepting the lesser amount, and that cancels the debt owed. If a secured note for a lesser amount is given and accepted in discharge of an unsecured debt, not for a greater amount, the difference between the two notes is discharged. The security is the consideration to support the contract to settle for the lesser sum. So once a dispute arises over how much is owed, the parties essentially begin negotiations over how much is going to be paid. So you have an offer and counter offer exchange, and once an amount is accepted during that negotiation, Then you have an offer, acceptance, and the lesser amount or the agreed upon amount is the consideration, so you have a valid contract. 8.2b, insufficient or invalid consideration. Performing or promising to perform what one is already obligated to do is not going to qualify as consideration. Refraining or promising to refrain from doing what one has no right to do also is not consideration. And any past performance act prior to the promise is not going to be sufficient consideration. 8.3a discusses voluntary subscriptions. Promises of individuals made to charitable enterprises are held enforceable and binding. Voluntary subscriptions are enforced as a matter of public policy. Debts of record. Consideration is not necessary to support an obligation of record, even on the basis of public policy. So if a judgment has been entered against you, that is going to be a debt of record. 8.3c, promissory estoppel, is where a promise is made. The promisor reasonably expects the promise to include action by the promisee. However, the promisee does not act, and that failure to act is detrimental to the promisor. In that situation, justice requires enforcement of the promise. Modification of sales contracts. If a sale of goods for contract is altered, no consideration is necessary to make it enforceable. Chapter 9, defective agreements. Mistakes. A unilateral mistake is one made by one party to the contract. A mutual mistake are mistakes made by both parties to a contract. Mutual mistakes, the court does not find these enforceable. Some courts find mutual mistakes void or voidable. A unilateral mistake, as a general rule, has no effect on the validity of a contract. (9.2c) contracts terms govern. If contract specifies what happens in the case of a mistake, the contract will apply if the law does not. A contract is what parties agreed to orally, even if written it says something else. Again, unilateral mistakes generally have no effect on the validity of a contract. However, a mutual mistake generally will make a contract invalid. There are a few exceptions. If the mutual mistake is regarding the value, quality, or price, then that will not invalidate the contract. Mutual mistakes as to the terms of the contract, the application of the law, or expectations also will not necessarily invalidate the contract. 9.4a, fraud in the inducement. This is where a party intended to make a contract based on false statements of the terms or obligations of the contracts. If you can prove fraud in the inducement, the contract is voidable. Fraud in the execution is where the defrauded party did not intend to sign a contract when the nature of the writing could not be understood. In this situation, the contract is void. Active fraud is where a party engages in action which causes the fraud. There are 4 elements of fraud: a material misrepresentation that must be made by one who knew the representation to be false or made it in reckless disregard of its truth or falsity. Must be made with the intent to induce an innocent party to act. The innocent party justifiably relies on that false statement and makes the contract. Passive fraud, this is covered in 9.4d. If a relationship is based on trust and confidence, silence may constitute passive fraud. However, as we discussed last class, silence in and of itself is neither acceptance of a contract nor is it fraud. Now, sometimes there may be an innocent misrepresentation, and this is where a false statement is made, but the party believes it to be true. In this situation, the contract is voidable. Statements of opinion. One's opinion does not constitute fraud. A misstatement of a valued opinion, however, can amount to fraud. Duress. Physical duress is where one party threatens the other with physical violence to get them to enter into a contract. This is unlawful and invalidates the contract. Emotional duress is one party's threat which affects the psychological ability of the other to act under free will. So think of a parent who has complete control over their child, even when their child reaches the age of majority. A parent could exert enough emotional duress to take away their adult child's ability to enter into a contract under their own free will. Economic duress is when one party financially threatens the other into a contract. It does not occur when one of the party members has a difficult financial circumstance or one party member drives a hard bargain to take advantage of the urgency of the other party. Undue influence. A person in a special relationship causes another action of someone they have undue influence over to act against his or her own free will. Contracts in this situation are voidable. Remedies for breach of contract because of fraud, duress, or undue influence. These 3 mistakes render a contract voidable. A party may rescind which is to set a contract aside, return what you have received under the contract, and terminate the contractual relationship. After rescission, one can bring a suit to recover monetary damages, to recover goods or other things of value given up, plus damages. After rescission of a contract, one can, if the contract is executory on your part, you may refuse to perform. If the other party sues, you can plead mistake, fraud, duress, or undue influence as a complete defense. After rescission, one can bring a suit to have the contract judicially declared void. If a written contract does not accurately express the parties' agreement, you may sue for judicial correction of the contract. This is called reformation of the contract. That covers our lecture on chapters 7, 8, and 9. The question for this lecture that I need you to answer by emailing me is the first Southern Miss football player to be inducted into the NFL Hall of Fame was Ray Guy, Rayguy. The first Southern Miss football player inducted into the NFL Hall of Fame was Ray Guy.